In Australia, a pre-nup is called a binding financial agreement, or BFA. Recent changes to the Family Law Act have extended BFAs to de facto couples as well as married people. Many people balk at the idea of a prenup. Some people think it's a romance killer, and others don't like the idea of entering into a relationship and talking about what might happen if it ends. On the other hand, when you buy a house, you buy insurance as well. And you don't do that because you're thinking of burning your house down one day, but because you realise that it's a possibility and that if you were left without insurance, the results could be disastrous. It's the same with a prenup. Increasingly in Australia, people are recognising that a BFA is a sensible thing to have. It can accommodate the complexities that arise in a blended family, and it can also serve to protect property that you've already accumulated. This is particularly important for people who are entering into a second or subsequent relationship. Coping with the pain, stress and emotional turmoil of a relationship breakdown is hard enough. You don't then want the uncertainty about what's going to happen in the future. A BFA can help because it sets out exactly what's going to happen and you know where you stand. All you have to do is put it into place. A BFA only kicks into action if you actually separate. If you don't separate, then it just sits in your bottom drawer along with the rest of your important papers. An important thing to know is that a BFA has to be correctly drafted to work. Near enough is not good enough in this area. It's not about one person ripping the other off. It's about both people deciding what's fair and knowing what's going to happen if their relationship does come to an end.